Welcome to Green Light for Justice, saving the world one case at a time.
This is Medical Malpractice in Maryland Explained, what patients and families should know. Michael, sir, welcome back.
Hi, Evan. How are you?
I'm well. So what does medical malpractice mean, like, legally?
Sure. People may have heard that term, medical malpractice. That's another way to say medical negligence. What is it means negligence occurring in the provision of medical services. What is negligence? Negligence is, legally speaking, when one person or persons have a duty to act in a certain way. They breach that duty and somebody else is harmed. So negligence is a concept that applies in civil cases, and um, it could be whether it's a motor vehicle crash, whether it's medical malpractice, whether it's premises liability. It's civil wrongdoing. It's an unintentional action usually, but the person who commits the negligence, the wrongdoing, um, acted below the required standard of care. When you're driving, you need to drive safely, and if you don't drive safely, that's negligence. Somebody gets hurt, that's negligence. In medical malpractice, medical negligence, if a doctor, nurse, nursing home, any other healthcare provider acts negligently or below the standard of care, that's negligence. And if they harm somebody, there's a potential civil case.
So how can you tell the difference between a bad medical outcome and maybe true malpractice?
Well, we look at the case because we look at the evidence, we talk to the potential clients and their families, we talk to witnesses, we review with a fine tooth comb the medical records, and we consult with medical expert witnesses to say, hey, this person had a bad outcome. Obviously, was it just a natural thing that could not have been avoided, or was it something that was a result of the doctor making a mistake, not paying attention, doing a procedure improperly, failing to advise or inform their patient of something that caused harm. And the medical experts help us figure that out. And a little bit of common sense.
So how are these? But what about medical records? How are they kind of used in a malpractice case?
Sure. So, just like had a conversation this morning with a potential client, and it sounds like he has a potential case. This one's so for me to determine whether there's a case worth pursuing, we're getting his medical records and we're going to look at them. We have a theory, just like teach the kids, what is a theory? A theory is, well, this is what seems that happened. Do we have any proof of this theory? Is this actually what happened? So take my 30 plus years of experience and look at listen to what the potential client is saying, and consult with some experts, and maybe do some medical research and say, well, these are the questions we need to ask and we need to have answered. And then we either have the client get the medical records or we get the medical records, and we look for things. We look for things in the records, and we look for things that should be in the records but are missing. And we put all the pieces of the puzzle together, and then we look at the puzzle, and if we have the proof, then we have a case.
When someone files a malpractice claim in Maryland, what kind of timeline should they expect from maybe start to finish?
Sure. Well, the most important thing is if you suspect that you have a potential case, reach out to an attorney as soon as you can, because there are time limitations, and in medical malpractice, they can be complicated to determine. So that's why you want to act as soon as you can. Even if you think it's too late, reach out anyway, because sometimes there are exceptions to the bringing the case. So that's the first thing, is reaching out to an attorney to have somebody get on the case right away. and start moving the case and investigating. So the investigation can take months to get the records, because the doctors don't always turn over the records as quickly as they're required by law. Then we have the records reviewed by experts, our firm, and then medical experts. And then if there's a case, we draft a lawsuit. There are certain requirements that are, I don't want to bore everybody with, but there are requirements of filing before we file in the Maryland Circuit Court or in the United States District Court. We have to file before an administrative agency, the Health Claims Alternative Dispute Resolution Office. So we have to go through there. We have to get our ticket out of there with our medical expert certificate. Then we file a suit in the circuit court, and the circuit court or the U.S. District Court is going to basically issue a scheduling order, which is going to say these are the dates that by which you have to make certain deadlines and do discovery and engage in motions practice, and then you'll have a settlement conference, and then a trial date at some point will be set. So it could be from the time you file a case to the time you finish a case. If the case gets tried, could be a year and a half. I mean, it could plus or minus months. There are situations where cases get appealed after that, and that could add on years to a case. So once again, that's why it's important to get started early, because these things take time.
What kind of damages can victims pursue?
Sure. In basically the two types of damages. One is called economic damages, and one is called non-economic damages. Your economic damages would be, for example, they could be past medical bills, future medical needs, which could run into hundreds of thousands of dollars.
Wow.
or more, depending on the severity of the medical injury. I mean, the medical injury, if there's brain damage or paralysis, paraplegia, quadriplegia, the damages are just astronomical. Life care to pay for life care of the patient. So those are your economic damage. You could have lost wages. You could have loss of earnings capacity. Imagine someone who's 20 years old and can't work for the rest of their life. We need to determine what their income would have been for their working life. Let's say age 20 through 65, millions of dollars, no matter even whether you're at a low paying job, medium paying job, or high paying job. So those are all these economic losses, which could be tremendous amounts of money. And then we have what's called non-economic damages. That's your pain, suffering, loss of passions, loss of abilities, the things that make us living, breathing humans. It's not that you're going to have to. There's not an economic loss in the sense that it's a payment of a medical bill or fixing your house up to make you get around. It's the fact that your friends are playing ball and you're sitting there in a wheelchair and can't move, below your neck, and just the horrible, that feeling, that emotional distress, that mental distress. What is that worth for a lifetime of living like that?
So, Mr. Greene, why are medical malpractice cases often harder for patients than any other type of injury cases?
Well, they can be harder because for a few reasons. One is that there are a lot of situations where, for example, if the case went to a jury trial, people just like healthcare providers. They like doctors. I don't know if they like hospitals so much, but
Yeah.
but they like doctors and don't want to find against them, even if they did do something wrong. So that could be one reason. Another reason is they're more complicated. Medical issues are more complicated to prove. That in turn results in a higher cost. we pay for the experts. The attorney will pay for the medical experts, and these experts charge a lot of money to review records and to testify. So they're expensive. So there are cases where we have to weigh how much will it cost to pursue the case versus what we can hope to get for the family and the injured person.
Yeah. So if a patient is worried about what the thing that happened to them isn't just a bad outcome, but actual malpractice, what would kind of advice or what would you tell them to do?
Well, that's the easy question. Just call a lawyer who handles these cases and talk, because the call is free, the consultation's free. It's the lawyer will, if they take the case, it's going to be on a contingency fee basis, meaning the lawyer does not get paid unless they make a recovery. So just call. It costs nothing. You can get peace of mind. I know when people call me, I'll stay on the phone with them as long as it takes to get to the bottom of things and to answer their questions, because it's, I'm trying to impart or to relay 30 years of knowledge to somebody, and I want them to understand it, and then to be able to make good decisions and take the right path.
Awesome. Michael Greene, sir, thank you for your time.
Thank you, Evan. I appreciate it very much.
Absolutely. And thank you for tuning in to Green Light for Justice, saving the world one case at a time. Medical malpractice cases are often complex, but experienced legal guidance can help protect them. To connect with Michael and his team, visit greenelegalservice.com or call 410-363-9414. Be sure to like, subscribe, leave a review, and share this message with someone that might find it helpful. Thank you so much for joining us, and we'll see you next time.
Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.